I pledge allegiance to the flag of the United States of America and to the republic which stands one nation, under God, indivisible, with liberty and justice for all. Some of you may have heard, I played golf a week ago with someone who was exposed to COVID, and I've had no symptoms. My wife has no symptoms, and but out of just being careful, I decided to conference in for this meeting. So during the discussions, Colette will, the vice president, will deal with public comments since I can't see who's there, and she'll also control the discussion on the three motions that we have pending again, since I can't see who's there. So the next item is approval of the agenda. Is there a motion to approve the agenda?
So moved.
Is there a second?
Second.
Any discussion? Seeing none, all in favor of the agenda, say aye.
Aye.
Aye. Any opposed? Any abstention? Okay, for the president's remarks, I just have just three remarks. First, again, this is a special meeting of the board. The purpose of this meeting is for the board to determine where we go from here regarding the FAR versus OPA litigation. We will be discussing whether or not to count the ballots or have a new election, but we will not be taking public comments on the litigation itself, and we will not be answering questions regarding the litigation itself. Our corporate counsel is at the meeting, and Jeremy, if we start to get a little bit offline, I would appreciate it if you would jump in to get us back on track. The second item is, I just want to remind everyone, the Communications Committee has asked me to remind everyone that the community survey is out there. They've got a good response so far, but if you haven't filled out the community survey, this is your opportunity to have some input into where the community goes after this. And the last remark is, again, the Communications Committee wanted me to remind everyone that in support of Worcester County's History Week, the history panel, the Ocean Pines History Panel, will be taking place on October 10th, and you can get onto the website for more information.
And Larry,
With
if
that,
I could, Larry, I just want to give proper credit to the Strategic Planning Advisory Committee, who was responsible for getting the homeowners survey out to the public. That was not the Communications Committee.
Oh, I'm sorry. Yeah, that's right.
Okay.
Okay, and so with that, I'm going to turn the floor over to Vice President Horn to handle the public comments. And your comments are limited to 5 minutes apiece.
So are there any public comments?
Slobodan Trendik, 20 Drawbridge Road. As I said earlier in some of my previous remarks, this is an unpleasant situation for all the parties involved, but most importantly, for membership who really had nothing to do with creating the situation. I'm going to try to make my comment in a constructive way and diplomatic way as much as possible. Let me first reflect on the comment made by Judge Campen a month ago during the hearing in August. And in one of his moments, he brought the following definition of term.
Mr. Trendik, we're not going to be discussing the
Okay. I wasn't
litigation
discussing litigation. I was just making a comment related to our governing documents. So the point was made, which relates to definition of terms in our bylaws, section 107, which basically defines the member. It refers to the owner of residential lot, condominium units, single-family attached
That
dwelling.
really doesn't relate to what we're discussing today. That goes
does
back
relate.
to the
It
issue
does- it does
of
relate.
litigation.
It does relate because you're going to be making
We
a
have two
decision on the
motions.
election.
We have two motions.
You have three motions according to
that
the
have
agenda.
to do with the decisions to either count the ballots or not and to run the election.
And the point I'm trying to make, I'm trying to
He's
remind
out of
this
order,
board,
Colette.
I'm
Th-
trying
this
to
does
remind
not
this
re-
board
Those
Of your
issues are
declar-
the issues having to do with litigation. Those are not the issues having to do with the decisions we're making today.
well,
Colette,
you-
could I
you-
suggest we ask our parliamentarian, we're hearing Mr. Perron say that he's out of order, and certainly this is discussion of litigation. Could I ask our parliamentarian for his take on this, please, Doug?
I'm going to defer to counsel since it's involved litigation. I'd rather put the onus on him to make sure we don't make any mistakes
Sure.
regarding what can and cannot be said.
Agreed.
Mr. Trendick, none of the motions for board today have to do with Mr. Farr's eligibility. So if your comments relate to an argument as to why Mr. Farr is eligible, that would be out of order. If your comments relate to specifically whether a new election without Mr. Farr, which won the ballot, should be done, then please limit that to that.
Sure.
comment.
I wasn't going to comment or say anything about eligibility issue, Jeremy.
Okay.
Thanks. No. What I was basically drawing attention to is our governing documents, which I believe, if they are followed, will help you make a decision on the motions that are before you today. That basically, you got to reflect on your regulations as opposed to just voting based on your opinion.
There really are no regulations that govern this
Right.
situation.
So,
We're outside the scope.
So,
that's
so
the
if you're
problem.
gonna, if you're gonna redo the election and you're gonna go based on Larry Perron's motion, basically what his motion says violates our bylaws, because to do election you need minimum 4 candidates. So that
That's
in
not
itself,
the
you're
case.
picking and choosing what you will enforce and what you will not enforce. So I'm directly making a comment related to Larry Perron's motion.
We need to have sufficient candidates to fill the vacancies. That's what the bylaw.
No, the bylaws require minimum 2 more candidates than open positions in order to run the election. And the board
If-
needs to do what it,
If there are eligible candidates that meet that requirement, which
Well-
we do not have.
well, when you're redoing the election, you can't just do a short version. You got to do a full-blown election, because otherwise you're basically, again, picking and choosing how you want to do it. And our bylaws, our governing documents spell out exactly how the election should be conducted. I was a secretary of the association. I know how the election needs to be conducted. I studied the governing documents.
This is not the conduct of a new election. This is the redo of an election that already had candidates vetted, corrections made to that vetting process, and that's the election that we will be doing. We will not be doing a new election. We
That's
will
not
not
what
be
the-
going back into the governing documents. We will be redoing the election that we have before us.
But that's not what the motion
Colette, the
states. It
bylaws
says conduct
also
the
give
new
the
election.
board the
Exactly.
ability
Thank you.
Excuse me,
To,
we have, Mr. Perone has the floor.
yeah, the bylaws also provide that the board has the right to do what they believe is necessary for the good of Ocean Pines. This issue was completely discussed last year when we decided to delay the assessments and allow the community additional time. So we have the right as a board to go ahead and do what we believe is correct for Ocean Pines. Is
Well,
there someone else with public comments?
Well, Mr. Trendick, I guess, are you?
as a parliamentarian,
Yeah,
Jeremy,
I
what
just-
Mr. Perone just stated, that the
Well,
board
so-
can do anything they want,
We're not-
including
Mr.
ignoring the
Trendick,
documents.
So, Mr. Trendick, I just to clarify, what you're contending is that in order to do what's proposed, whether the redo of the election without Mr. Farr on the ballot is improper under the bylaw.
Yeah, basically what I'm saying is
So
that
you
the
would
board
want
is going to,
go out for nomination again, open up the nomination process again.
follow the
solicit-
bylaws.
Solicit new nominations and do that that's what you.
Basically, all I'm saying is the board should follow the bylaws, our governing documents. That's all I'm asking.
And so the part of the bylaws that you're choosing has nothing to do with the dates, the timeframes, any of the other things that are in the bylaws. You are choosing the part of the bylaws you would like us to pay attention to. Exactly what you're accusing us of doing. So I think
I'm not
so does
accusing you
anybody-
of anything.
But does anybody else have public comments?
So you're actually dismissing me.
anybody else
My
have
5
public
minutes have not been over.
Your
have not-
5 minutes are way over.
Nothing has changed. I'm really, really disappointed. I can't believe.
Does anybody else have public comments? Okay. Okay, step up.
What a beautiful afternoon. And it's absolutely gorgeous out there, isn't
Mhm.
it? 198 Ocean Parkway, Tom Schwartz, homeowner. The proposed motions to rescind and the proposal to continue with a 3-person ballot should be rejected today. You shouldn't do anything. You shouldn't do anything. You should wait for the current situation to resolve itself that's gone to the court. Now, I'm not trying to litigate anything in front of you. I'm just trying to give you knowledge or express a concern that you all are jumping the shark on what is already being done with the lawyers. The fact that the 27th of September did not provide good fruit, we need to wait. You're jumping the shark. You're doing things that are going to embarrass you, regardless of the outcome. You're embarrassing yourselves doing this. You're right in the middle of a transaction, and you're moving ahead like nothing's going to change. It may not change. You don't know that answer yet. That's all. Thank you very much. That's not litigating anything. That's just trying to express to you that where you're going at this moment is ahead of the ball game. Thank you.
Thank you.
Thank you, Mr. Schwartz.
Are there any other public comments? Seeing none? Oh, sorry.
Excuse me for my hesitation. My name's Peter Arishtian, 76 Martin East Circle. First off, thank you for the opportunity to speak today. In regards to what the judge said, and I'm not going to talk about the litigation, but I will speak about what he said. From the bench regarding the election, he hoped that the OPA board would do the right thing. The real question is, for whom will the board do the right thing? Will you consider the rights and the votes of the OPA owners, for whom you represent? Or will you act contrary to the DRs and do what is easiest and most advantageous for the majority of the board? That's my view, my personal view. This process has fractured our community, and you now have the opportunity to pull it back together or deepen the divide. So do the right thing. Thank you.
Thank you. Any other public comments? Okay, seeing none, we will move on to the first motion. Larry?
Yeah. Okay, there's I moved to, wait a second. You got it backwards. Yeah, I moved to rescind the standing motion to count the 2021 election ballots passed on July 30th, 2021 and amended on September 9th, 2021. The purpose and effect. The purpose of rescinding the standing motion is to allow the board to consider redoing the Board of Directors election of 2021. The effect of rescinding the amended motion will allow consideration of a new election of the three eligible candidates, Daley, Hardy, and Lackernick. Background: the standing motion was passed after the Secretary of the Ocean Pines Association declared Rick Farr ineligible to run for the 2021 Board of Director elections. Farr initiated litigation and was granted a temporary restraining order against Ocean Pines, the Ocean Pines Association, counting the ballots or announcing the winning candidates. The TRO has expired, and the court denied Farr his motion for a preliminary injunction. The board decided to wait on counting votes until the motions hearing on September 27, 2021. At that hearing, no action was taken. The board is free to continue to do the business of running the Ocean Pines Association and conducting a new election where all members can vote on the three eligible candidates.
Is there a second? Is there a second to that motion? I'll second it. Any discussion?
Floor's not open for discussion.
What is your inquiry?
My name is Grant Helvey, 1443 Ocean Parkway. It's my understanding the board's supposed to function according to Robert's Rules of Order.
He's out of order, Colette.
Are you calling a point of order?
Yes.
Technically, he cannot call a point of order.
Okay.
He can't
So you're
call
out
a
of
point
order.
of order.
Assembly.
Sorry,
He's
thank
out of
you,
order.
Mr. Tucker.
But to the point, the board of directors is permitted to rescind, under Robert's Rules of Order, there's two ways to rescind an existing decision that has not been carried out. One is a motion can be rescinded at any time without notice, provided that there's a 2/3 vote to rescind. If there is advance notice, then it requires a majority decision of the board to rescind the motion under Robert's Rules of Order.
I'm sorry, I didn't hear that last part.
If there's prior notice of the intent to rescind a decision that has not been carried out, then it only requires a majority vote. If there has been no notice of the motion to rescind, then it requires a 2/3 vote to rescind an order if it has not been carried out. I previously emailed the board about this several months ago based on the citation from Robert's Rules of Order.
Okay, is there any discussion of this motion?
I didn't hear a motion.
It's
I
pretty
will
regular,
repeat
Mr.
the
Hawley.
motion. The motion is to rescind the standing motion to count the 2020 election ballots passed on July 30th, 2021, and amended on September 9, 2021. It was submitted by Mr. Perone. I seconded it. Is there any discussion? Doug?
So I've been thinking about the need for this motion, and I'm of two minds. Number one, if we move forward, it's procedural, right? So if I decide to support this, I wanted to be very clear that I'm supporting it on the basis of the procedural requirements, not that I believe that anything else beyond rescinding this motion should happen. I'm not supporting any other position other than procedural. So I believe that I will support this, but again, very important to realize only because procedurally, if we don't pass this, we don't have any other options. We'll continue to do business based on the decision was made at the last meeting.
Any other discussion? Okay. All in favor?
Aye.
Aye.
So I was Perone, Parks, myself,
Yes.
Rogers, and Brown. Any opposed? Any abstentions? Did you vote?
I said aye.
Oh, I'm sorry.
Frank, did you abstain or?
I voted. Aye.
Okay. Okay, the motion carries. Excuse me? It was all in favor. It was all in favor, 700 was the vote. Okay, and then we have another motion.
Okay. I move to conduct a new election for the 2021 Board of Directors. The election ballot will include the 3 eligible candidates, Daly, Hardy, and Lackernick. Purpose and effect: candidate Farr was ruled ineligible during the conduct of the 2021 Board of Directors election. The Ocean Pines community has made it clear to several board members that they want their 2 votes to count. Holding a new election for 3 eligible candidates will give the OPA community a chance to vote again with 2 valid votes. Background: Secretary of the Ocean Pines Association declared Rick Farr ineligible to run for the 2021 Board of Directors elections. Farr initiated litigation and was granted a temporary restraining order against Ocean Pines Association, counting the ballots or announcing the winning candidates. The TRO has expired, and the court denied Farr's motion for a preliminary injunction. The board decided to wait on counting votes until a motion hearing on September 27, 2021. At that hearing, no action was taken. The board is free to continue the business of running the Ocean Pines Association and conducting a new election where all members can vote on the 3 eligible candidates. The pending litigation could take many months, if not years, to resolve. The board should move forward with a new election and seat the new directors after the new election process is completed.
Is there a second?
Second.
Any discussion?
Yes. I just seconded this so we could actually chat about it a little bit. I am of 2 minds on this. Certainly, we have heard an awful lot from the citizens of Ocean Pines, and in all candor, I would like to do the right thing. I would really like to see us do the right thing, but I'm confused about what the right thing is. I think that the people that are in Ocean Pines are of 2 minds. They would like to know how the election actually turned out. I think that that's a valid point. I think that our candidates are entitled to know that, but to what end? What good does that do? Until Judge Camden, if he does, say anything about the eligibility of Mr. Farr, we're still in the same place. I have practiced in the courts here and around the state for a long time, and what I want you to know is that this is going to take a long, long time. Courts are only now getting back into place after COVID. I think that whatever we do, whether it is count the votes and not count Mr. Farr's, to count the votes, disclose that, and see where we are, and hold a new election, I think that all of those are really good options. I know that there is someone here who is concerned about whether that is consistent with our bylaws, and for that, I'd like to ask Mr. Tucker to weigh in on that.
So the bylaws provide that, the committee will attempt to obtain sufficient nominees, and if they don't, the election will move forward. But this is, what I would suggest is eventually that we're going to entertain if this moves forward, an amendment. We're redoing the election. We're not holding a new election. We're redoing the election without Mr. Farr's name on the ballot, if that's where you want to move forward. Let's be honest. None of this is contemplated by the bylaws. None of what has transpired is contemplated by the bylaws. The board is trying to do whatever decision they best they can to come to an outcome that is in the best interest of the community, in compliance with the bylaws to the best of its ability, and consistent with Maryland law. Redoing elections is a standard issue when there are potentially irregularities or issues that come up with the vote. That's one method of correcting it. Here, you are left with, like exactly Ms. Rogers indicated, multiple options, none of which are great. um, for many reasons, none of which are bad either. Seating a new board, no matter how that board is determined, if the court ultimately comes to a different outcome, that creates some issues that the court will have to resolve. Continuing in the current status quo for the duration of the court creates concerns too, that we have directors that terms have expired, they're holdover directors, but how long are they going to remain as holdover directors? So none of them are great. There are no, just like with before, there are no wonderful, perfect solutions to solve this. But yes, you could proceed with it. There's no law. It doesn't directly apply. You could, of course, decide to reopen for nominations and start the process again, even though that does not comply with your policies, which have certain strike dates for nominations and things like that. That would have to be addressed. But you have three candidates, three that have been deemed eligible at this current time. But they remain candidates because the vote count is not done. You could proceed and do the new election, redo of the election with those three candidates, if that's what you choose to do. Or you could look at the previous motion and see if that's how you want to.
Colette, may I add just one more thing, please?
Yes.
Mr. Tucker, if we hold off now, we are about, time flies, but we're about to enter yet another election cycle. That starts in April and that will be here before we know it. Would what we are doing by holding steady invalidate another election, or can that election go on if we have a holdover board?
So it's speculation at this point, depending on when and if the judge makes a decision. But let's hypothetically, if we held in place with the current board in place through next summer, okay, which we can talk about, and the judge at some point in time indicates that let's say it happens in June or July, indicates that Mr. Farr is not eligible, and the decision was correct, then what I would recommend at that time is that we would add, I don't know how many positions are open next year, forgive me, add that other position to the ballot, and they would fill that vacancy in the election for that term. So it would be the highest vote getter would get the 3-year terms, and however, that position would get a 2-year term.
And that's not in violation of HOA law?
No. If that went out, and that, again, that's a hypothetical that plays out quite a bit of where we end up with things. If summary judgment motions are set in December, for example, and Mr. Farr is ruled ineligible in December, then different options may present. If Mr. Farr is deemed eligible in December and we move forward with that termination, then he would, this is all, again, I don't want to speculate too much because I have no idea what the judge will decide. How the judge decides. Then we'll have to deal with how the judge decides and what the remedy is for what the judge decides.
Tom?
All right. This is apparent. This is all open to interpretation. Obviously, if the judge thought either direction we were going, eligible or ineligible, we would have made a decision by now. As it keeps going on, this litigation could go on for months and months and months.
Mm-hmm.
If we decide to go with a new election, as this motion is stating, the election is going to take at least 8 weeks, if not up to 12, to get all the documentation and get it out there. If in the meantime, while we're doing this new election, the judge comes down with a ruling that Mr. Farr is eligible, then we've just spent $20,000 doing an election that's moot completely, because at that point we count the old votes. So who are we alienating here? Obviously, if we go with the new election, we're putting ourselves in a position of the judge comes back, says Rick is eligible, and we've just spent the money on a new election, and all those votes are useless, and people voted again, and none of their votes count. If we go with Doug's motion and count all the votes and deem all of Mr. Farr's votes ineligible, there are people that are going to say, well, why didn't I get 2 votes? Well, again, I'll go to one of the ex-board members said, if somebody dies during the election, you don't get 2 votes either. So my point is, I think doing a whole new election, especially in the midst of all this turmoil, doesn't make any sense. I'm of the philosophy of crap or get off the pot. And we've been on the pot for way too long. It's time to just count the votes that we have, deem the election done. If we decided that Rick's ineligible, this is what the judge told us to do anyway, was to count the votes. Let's just do it and seat our board. Because this could go on. We could have the same temporary lame duck board for the next 8 months until the next election. That's my opinion. I think that we should, that this shouldn't pass. I think we should go with Doug's motion, count these votes tomorrow, put the nomination out there for whoever it was that won, and get this board seated. Because it's going on too long, and it could go on for months and months and months. And it's just tiresome, and it's a laughing stock, and it's just insane. I mean, it really is. Nobody did this on purpose. None of it was done on purpose. To take it out on Cammie, shame on whomever is doing all that. You should be ashamed of yourself. To take it out on people in the association and send threatening emails, shame on you for doing that too. This was a no-win situation. Everybody did what they thought was correct. People are spending lots of money to prove that what they did was correct. Luckily for us, it's 8,500 homeowners' money, so we don't have to, we're spending pennies. Some people are spending thousands. I think we end this. Let's get it over with. Let's get the ballots counted. Let's find out who won. We already said that Rick's ineligible. Let's deem him ineligible, and let's move on.
Doug?
Yeah, I've given this motion some thought, and I'm going to vote against it on 3 particular fronts: cost, time, and legal coordination. We've already invested money in the first election. I believe, and Steve, correct me if I'm wrong, we're talking in the neighborhood of 15 to 20K to run another election right in there. So we can validate that, additional expense. The second thing was, and Steve, I believe I talked to you some time ago about another election, it would be at the very least 8 weeks. And I would offer that with the glacial pace at which we do things around here, that could certainly be pushed to, 12 and beyond, maybe 3 months, okay? 3 months of I don't want to use I'm going to disagree with Tom on the term lame duck, but the rancor, the chaos, and the uncertainty. And the community doesn't deserve that. All right. The third situation is legal coordination. The case is still pending. We may get a judgment that says candidate Farr is eligible. We have to account for that. I don't want to flippantly just throw another, process and expense because we think we know what the outcome is going to be. I'm not a betting man. I'm not a gambler. I like to analyze, I like to study, and I like to try to make an informed decision. I'm not going to vote to have another election. And I also want to say I am sensitive to the people who believe their votes are disenfranchised. I will not argue that point. That's difficult, all right? And I've thought about that. But I have to say, based on all the other factors that are important to me in representing the community here of Ocean Pines, I don't think it's fair to run another election. And based on what we heard from the judge, that's public knowledge, I believe, and that's why I introduced a motion that you'll see come up here soon, that I do not support having another election.
Colette.
Yes.
Tom, in your scenario, I just need to understand what your thought process is. And also thank you for the support that you've given me throughout this whole ordeal. In your scenario, are you saying that we count all the votes, Mr. Farr remains ineligible, and we take the top vote getters that are left?
Yes.
Okay, thank you.
Okay, I have some comments. I don't, what we've heard from Directors Parks and Janicek is that we don't want to make decisions that are based on assumptions about what the outcome of this litigation will be. But I think either option of counting all the votes, declaring Mr. Farr's ineligible, or holding an election with 3 candidates essentially are doing the same thing. They're both based on an assumption that the court will affirm the decision made by Director Rogers about the eligibility. So I don't really see one resolving that situation more effectively or fairly than the other. So that's one point. This is an unprecedented situation. And I was very concerned when the idea of running another election with 3 candidates came up, that would set a new precedent for challenges to our elections and putting us in a position of having to decide to rerun elections. I'm very loath to set a precedent of that nature. The fact that this is an unprecedented situation, one that has never occurred in the history of the association in the past, and if we do the work that we need to do as a board to tighten up our election candidate verification process, it should not happen again. So I'm much less concerned about this setting a precedent that we would regret or that we would burden future boards with. The concern that I have is that the election that's been run, the votes that have been cast, really are based on what one might consider an invalid election. There was a kind of tainting of the water in the midst of the election. And so people's minds changed about how they would have voted had they had information when they voted that they got later. And there were fewer choices later in the election. And so in my view, the votes that are yet to be counted are based on an election that might well be considered an invalid election based on the muddying of the waters through all of this. So I'm not really crazy about the option of counting those ballots and considering those votes to be based on a valid election. I agree that running an election with 3 candidates is fraught, and the court may come back and say, wait a minute, you shouldn't have done that because lo and behold, Mr. Farr's claim of eligibility is upheld. I agree with what Mr. Tucker has said, that none of these options are good options. And what I think we each as directors are obligated to do is choose the option that is least troublesome, that in our view is, in the words of Mr. Schwartz, I think it was that? No. What was your name, sir? That we do the right thing. And I think what we're all trying to do is do the right thing. But as Director Rogers pointed out, it's not easy sitting up here to know what the right thing is because there are competing interests in this community. And, that's why we have disputed elections, when there are competing interests all vying for the outcome that they prefer. So I don't think there are easy answers. And I think, you may look at it differently sitting out there. For us, the burden rests heavily on our shoulders to make a determination as to what the right thing is. And in my view, we have votes that are based on an invalid election. We have voters who feel that they want their vote to count and to matter. And that kind of leans my thinking more toward, let's run a new election with candidates that are certified based on the decision that has been made in good faith, using the wisdom of our governing documents and the precedent that has been set for how owner of record has been interpreted throughout the years that we've held elections. And so I'm leaning toward the idea of supporting this motion to rerun the election. I think that weighs a little more heavily in favor of doing the right thing, as I see it. Doug?
So I'm going to agree with what you said earlier. There's no silver bullet here. Neither one of the solutions are going to produce a result that's amicable for everybody. However, to be brutally honest, One solution will cost us expenses and time. Another solution will cost us some, I guess, maybe embarrassment if we had to unseat a director. All right? I'd be far more willing to do that than I would to invest, or in this case, perhaps arguably waste another $20,000 worth of the association's money getting on the potential, that we couldn't finish the election and we have to go back and do it anyway. So from a risk perspective, the risk, from a time and a cost perspective, is far less if we just count the votes, seat, and then take the action required based on the decision of the judge in this case.
Yeah, I want to, you said that both of these decisions are based on an assumption, and I agree with you with the major exception of what Doug said. There's one big, huge exception. It's association money and association time. I mean, it's time. It's 8 to 12 weeks. It's a lot of money. And the simple fact is, it could end up with the exact same outcome as counting the votes tomorrow. The exact same outcome. That's my point. And it's over with and done. And if there's litigation that comes up after the fact, then we deal with it then. But to go out and redo the whole election, it's cost in effect. It's costly and it's time consuming. And I just that's why I can't vote for this. We have election, we have ballots sitting in a box. My opinion is count them up. They've been sitting there for a month. Let's get it over with. I mean, we took this position for the heavy burden on our shoulders. I have no problem. It's time to do something and get it done. I mean, this is why we're here. Nobody else wants to, it's not easy to get people to run for this board. You can see it every year. And everybody that says, oh, I'm going to run next year to make up for this, I'll wait for the list. But I'm here and I'm willing to say, let's count them up and get it done. I'll take the responsibility. But to spend more money and do this election over again and take 2 months, 3 months to get it done, I'm not willing. It's hard to sit through it all over again. And when we have the votes sitting in a box, I say let's count them and be done with it.
Colette, can I be heard?
Yes.
So, of course, this is my motion, and I think we should do a new election based on the feedback that I have received from many, many community members. I want to make a couple points. First off, the stakes of what are occurring here, the financial impact, while nobody likes to spend additional money, that should not be a factor in what we do here. This mess was brought on by the fact that a candidate indicated to the community and then on his application that he was a homeowner.
Larry, this is Jeremy. I'm just gonna cut you off on that at this point. And so I understand your point, but I don't think it's appropriate given the status of the litigation. But
all right. Well, then I wanted to address also this issue of how long this may take. Again, as I say in the motion, this could take many, many months, and it could be years until the issue is resolved. I don't believe we can just sit and do nothing. I agree with Colette Horn that the votes have been tainted, and I think based on the input I'm getting from the community that we should do a new election with the eligible candidates. I'll leave it at that.
Look. Okay.
No, go ahead, Kim. Let me, I want to read statement.
Thank you. I think that there's one variable that, in order for me to make a vote on this particular motion, I need to know. And I would ask Jeremy if we could briefly suspend Robert's Rules of Order so I could ask Mr. Haberger a question.
Kim, you have to ask the chair.
Oh, I'm sorry.
Yes. I will allow you to ask Mr. Hubbard.
Thank you. And I really ask this not to put you on the spot, Steve, but Yeah, okay. I, yeah.
That's the spot.
I have a concern that when all of this came to light on July the 28th, what percentage of votes were actually in by then? Do you have any idea, were the majority already received, or was there a big deluge the 1st of August?
We don't know.
Okay.
We
that's fair.
don't track arrival of ballots until the deadline. So it generally follows an S curve. It kind of starts slow, ramps up, and then kind of, but I can't provide that information. I don't know.
No, that's fair.
Yeah.
That's fair. How many votes came in late?
Oh, golly, over 300.
The ones that were from Hawaii, though?
Yeah, we had one from Honolulu that came in late. But the vast majority of the ones that were late were, no, don't forget, business reply envelopes are not necessarily postmarked because they're already paid. So most of the ones that I've reviewed are either from Wilkes-Barre, Pennsylvania or Baltimore, Maryland. Now it's important to recognize that if you drop an outgoing mail into Ocean Pines mailbox, it's postmarked Baltimore. It travels to Baltimore where it's sorted, photographed, and all and sent back. So it just means that in big Maryland and what's Wilkes-Barre? Is that Eastern Pennsylvania? I'm not familiar, but anyway, wherever that major post office is, that's where the majority of the late ballots have been coming from. And I think it's an artifact of the U.S. Postal Service.
Does that satisfy your need?
Yeah, it does. I guess
So
I'm just,
gonna close- I'm gonna resume.
okay, thank you.
Robert's Rules of Order.
Thanks.
Doug?
Yeah, I want to make sure I understood. You made a comment that the ballots were tainted, and I'm going to respectfully disagree with that because in essence, if you look at the timeline associated with the submission of ballots, when the secretary made the initial decision to validate all the candidates, people took that and cast their vote accordingly. So those votes were cast legally, all right? And it wasn't until this technicality, and let's call it what it is, we're dealing with a technicality, and I agree, there should be discussed, it is a technicality, that turns around and invalidates those votes. But I want to make sure that the membership, at least me, I don't have the idea that this election was tainted from the get-go, you know, and that we've made an egregious mistake and we have to correct it. I think we're taking the right steps, but remember to sort of generally classify ballots that were submitted before the issue came up, call them illegitimate or tainted. I'm going to respectfully disagree with that.
Okay, any other discussion?
Yeah, I'll say something. Look, to this point in time, for a lot of reasons, I have not said anything. I'm going to vote for this motion, but it has nothing basically to do with Ocean Pines. In America, the right to vote is sacred. Some people choose that right. Some people don't pay attention to it. Some people defend it. Some have died for it. Some people lost their votes. That's why we need another election. Plain and simple.
Can I ask Jeremy, based on the fact that we had an election and Frank is included in the election, and this is nothing personal, and that this election, this amendment basically says Frank has to run against one less candidate if we do a new election. Should Frank be able to vote on this motion?
So legally, it's not the definition of a conflict of interest, but my recommendation, Frank, given the pending litigation, is that you abstain from this vote as you are an interested party to this decision. I'm not saying by law you have to abstain, but it will certainly be raised in the litigation. I would imagine if your participation in this vote. I can't tell you that you don't have the right to vote, but I would say that if we play out what will happen with it, you can imagine how it will be spoken, used about. So I would caution and recommend that you abstain from the vote. I know it will be difficult.
Yep, just one last comment. Sorry, I didn't think I was going to be of two minds when I was sitting here, but I have to admit I'm very conflicted about this. I guess I feel this overwhelming need to be able to heal this community. And that's what I have to really consider in this vote, because we are really in a state of chaos. When I can't walk into the food line without being accosted, there's something horribly wrong. And yeah, this, and I don't want anyone here to think that this is easy, because it's not. I mean, and it's been a battle for me, but I know it's been a battle for Mr. Farr too. So I want to acknowledge that, and I hope that whatever we decide to do, that we can move forward. That's it.
Okay, I'm going to do a roll call.
So Colette, back to your comment that we could be setting a precedent. I agree. I think that's something that we need to consider, that although this situation has been unprecedented, what we decide here today will set some sort of precedent that will be referenced by future boards. And one of the things that sort of short and sweet is, if we hold another election, so be it. As you know my position on it. However, if we're talking about precedent setting, what happens if the same situation comes up? We start collecting ballots, and then someone drops out of the race. All right. So again, we're faced with the I'm disenfranchised. My vote didn't count. Will we hold another election again? Because if we're talking about, and I'm agreeing with you, we have to think about the precedent. If that happens, will we be required to have another election by setting this precedent? Just giving some people something to think about. Because if we set this precedent, it may come back to not be as advantageous as we would hope it would be in the future.
Any other comments? Okay. So I'm going to do a roll call vote. Tom?
No. No.
Doug? Frank?
He's not voting.
With all due respect to your advice, yes.
Cammy?
No.
Brown?
Yes.
Larry?
Yes.
And my vote will be yes. So the motion carries. That's a vote of 4-3-0. Doug, you have a motion?
I move to conduct an official count of the 2021 election ballots to include all 4 of the candidates that were on the ballot, and to designate the votes for candidate Farr as ineligible. Purpose and effect: the count of all the ballots received will inform the public of their sentiment on the candidates and exhibit full disclosure to the OPA membership. Background: while candidate Farr has been ruled ineligible, the court case is still pending, and a final decision has not yet been rendered. Referencing the statement made by the judge that he thought it would be good to count all the votes, but to count the ones for Farr as ineligible, consideration should be given to his suggestion. Counting the votes, as noted, will lend clarity to the current situation and assist with getting a final resolution of validating the election and seating new board members.
Is there a second?
Second.
Discussion?
I just have just an administrative point on this. So if the motion proceeds, for clarity, that all of the votes will be deemed now ineligible based on the motion that just passed, but you would be counting the votes for the purposes of just noting what those votes were.
I'm sorry, can you say that again?
Because you just passed a motion to proceed with a redo election with 3 candidates, okay? Because that is what it will be, and then you would, that is how it will be. If Doug's motion, what I would recommend is an amendment to Doug's motion, is that all of the votes would be deemed ineligible, but you would count the votes for the purposes of whatever we want to call it for illumination, but so that vote totals would be given, but the new vote would occur, given the adoption of the prior.
Thank you. Tammy?
Jeremy, I think that's a really good idea. I think that one of the things that the community has struggled with is transparency in all of this. And that certainly would lend that if Doug would accept that as a friendly amendment.
That procedurally, that doesn't need to be an amendment,
Doesn't have
does
to be
it?
an amendment.
That kind of goes without saying. Okay.
Well, I just wanted to make sure we're all.
Yeah.
I just want to make sure that we're all clear and everybody else is clear that if this motion passes, so there is no conflict between the two motions. So there's clarity to that both for here and everybody listening, that we're not adopted. If this is adopted, we're not adopting conflicting resolutions.
Okay. Doug?
Well, clearly I brought this motion forward with the issue of full transparency. Let's not forget whose election this is. This is not the board's election. It is the community's election. And hiding the outcome, despite the fact that, there was some question about eligibility, all right, which by the way has been resolved as far as going forward, eligibility is certainly there, is kind of obfuscates the whole issue. I think we as a board need to at least demonstrate, however, the fact that Jeremy, I knew this was going to happen, where they would become ineligible if this motion passed. But I believe we owe it to the membership to share with them how that sentiment in the community really feels about these candidates. Right? I also think it will help influence their decision in this quote unquote new election. But to withhold this information is an egregious mistake. And I go back to the fact that I believe, my own personal opinion, that when the judge made that statement, he gave a not so subtle hint to the organization that he would like to see those votes counted, because I believe he felt it was relevant. I could be wrong, but it's my opinion. And the fact that if we continue to withhold this information, we are not acting in the best interest of the association membership.
Tom?
Yeah, obviously I'm going to agree with Doug. The last vote went a little awry. I didn't expect it to go that way. But the simple fact is that there was an election, full-on election. It got interrupted with about 10 days left or 7 days left or whatever it may be. But there are a lot of people in this community, our community, not just 7 of us. There's 8,500 homes of us that all participated. Not all participated, but I guarantee you a majority did. This election has been far from normal. Probably go down as one of the worst things that Ocean Pines has gone through. And I think that the public at large, Ocean Pines Association members, deserve to know how they voted and what happened. I mean, this needs to come out. We've been holding on to this for a month, waiting for a judge to make an order and tell the board what to do because we couldn't make our own decision. Now we're going to go ahead and have another election, which I truly don't believe is the right way to go, but that's okay. It was passed. But I do believe, as Doug said, the people of Ocean Pines deserve to know what happened in that election. And then they can, and they're going to get their ballots in 3 weeks and they can vote again. But they deserve to know they made the vote. They took the time. They voiced their opinions in both ways. But I do believe that it needs to come out. And that's why I will support this motion.
Larry? Any comments?
Yeah, I just think that at this point, since the board voted to do a new election, this is counterproductive. And I suspect that at some point, the judge will order that we count the votes. However, he has not ordered that we count the votes. He made it clear that he was not going to instruct Ocean Pines what to do. And in fact, his order just calls for us to preserve the ballots. So it's my belief that we should, now that we've agreed to a new election, that we should not support this motion.
Doug?
Yeah, and Director Prunn's right. The judge ordered everything to be kept. However, one would argue that why would one decide in order to keep the ballots? Probably because it might be relevant to count them as the litigation moves forward. By the way, I suspect, and it doesn't take a rocket science to figure out, that if it goes to further litigation, which might involve a trial, I suspect there'll be discovery, and they'll come out anyway, and it'll be public knowledge.
Pammy?
Yeah, just to correct one thing, Judge Camden did not order us to count the ballots. He ordered us to
hold the ballots.
Exactly. He ordered us to do the right thing, and that was a suggestion that hold a new election. And there has been a lot of talk in the community that we were ordered to count the ballots, and we were not.
Tom?
The statement, I had a statement, it says, ordered that the entire ballot count shall be preserved. So, count is it's interpretive, I guess, but in my opinion, ballot count means let's count the ballots, preserve that way the information is out there. So if we do end up in court, it's already done. It's going to come out anyway. So I agree with Doug's motion. I'm going to vote for it. I guess again, there's really, I'm kind of just spitting in the wind, but I think the public in Ocean Pines at large deserves to know what happened in this election. And I think they need to know it now.
Okay, and I will comment as well. Doug, I agree with you that the election belongs to the community. The community has made it very clear to us that they want their vote to matter. And I've heard from many people in the community who would prefer that we rerun this election with the three eligible candidates. The point that you make about the sentiment of the voters, I'm also hearing loud and clear from the community that their sentiments have changed, and they want that reflected in the way they vote in a rerun election. I also agree that counting these votes could have an influence on, if done before we would redo the election, it could have an influence on that election. Which direction that influence would go is anybody's guess. But I think it would taint a redone election to kind of throw that kind of a monkey wrench into it. I agree with what Directors Rogers and Perone have said about the fact that the judge did not direct us to count the votes, that he wanted us to preserve the votes. And I think he probably did that because at some point he will want them counted, but he is not, the order that has come out and the off-the-cuff remarks that he has made indicate to me that he does not want to influence the outcome of whatever decision-making that we do at this juncture as a board. He wants us to be able to move forward without his influence. And I think it is time to move forward. That's what I'm also hearing from the community. They don't want this to drag on. They want us to bring it to a resolution. Doug?
Yeah, and I know what's going on, but it's an important issue. I want to make sure we cover everything. I mean, yourself, Dr. Perone, have said the people I've talked to, and you've expressed what they've told you. I've talked to a lot of people as well, and there's two sentiments that are clear in all the people that I talk to, and that is we want this over. We want it over as soon as possible. I don't care who wins. All right, we just want it over. We want this uncertainty and all the chaos associated with this entire process to just go away. And that's why I introduced the motion to just count them, because three things can happen. Candidate Farr isn't in the top two. Case closed. We can move forward in a timely and effective manner. Oh, by the way, budget season just started. It's important that we consider sitting new directors and get them acclimated to the budget process as we move forward in the budget preparation. I hope everybody's thinking about that. Number two, if candidate Farr happens to be in the top two, we seat him and the judge says, you're ineligible, we unseat him, we have a process to replace that director, we take that, guess what? We can move forward, it's to shorten the time frame. And the third condition would be Candidate Farr happened to be in the top 2. We seat him, and then the judge says he is eligible. We can continue to move on. It's all about timing and cost. And note to me, I just distilled it down into 3 simple, straightforward approaches. And I said that in our prior meetings, and I stand by what I said. That's what I firmly believe we should do. And I just want to make sure, because it sounds like maybe you didn't understand what I was saying. I didn't say that the judge told us to count the votes. I said the vote, and if you go back, and I brought these emails here that basically say that the judge said it would be interesting. He hinted that the votes probably should be counted, but he said, and I quote, "I cannot tell you what to do. It's your business. Do the right thing." All right. So I just want to make sure, in case anybody misunderstood what I said, I didn't say that the judge told us to count the votes, but I believe he gave us a strong indication of his preference on that particular matter.
Agreed.
I don't normally use that statement very often, but since Director Perone and Director Horn continue to use that, the people that they talked to said they want a new election, I would tend to venture to say that I probably talk to hundreds of people weeks and months. I'm everywhere. And the people I talk to, since we're going in that direction, state that they wanted the election ballots counted and they want this thing over with. So just if we're going to use that statement, we all have different groups of people that we talk to. We're all in different groups of community memberships and things, golf clubs, mahjong, whatever, tennis and things. We all talk to different people. The simple fact is that there's 8,500 homes and the votes should be counted. That's the thing. They all voted, let them be counted. The people I talk to want the votes counted. They want this done. They don't want to deal with it anymore. So that's my opinion on the people we talk to.
I'm sorry, I do have one more question, Colette, if I may.
Okay.
Doug, could you, I'm not sure I heard you correctly, and I want to make sure I know what you're talking about. Your motion says that motion conduct an official count to include all 4 of the candidates who were on the ballot and to designate the votes for candidate Farr as ineligible, which means we could not seat him even if he came in second.
Doesn't matter. At this point, it's all moot anyway because of the other motion.
Yeah.
Okay, all right.
Correct. We wouldn't seat him. We'd probably have to have another meeting that said, do we fill the position? Do we get a sense from, the idea would be, if we know the litigation is going to continue and take a long time, we might have to appoint a director. If we get an indication from the court, we would ask the judge for some consideration and say, we're about ready to take this course of action. I know he's vested in the case itself. If you think a decision is forthcoming, we'll wait for your decision. So I would approach the judge and present that situation to him and ask him for some consideration.
Okay.
But it doesn't matter now.
Okay, so I'd like to have a roll call vote. Tom?
Yes.
Oh, sorry. Doug?
Point of order. At one point earlier in the conversation, there was a mention of a friendly amendment, potential friendly amendment, since the previous motion was passed, and based on advice from counsel, all of the votes will be listed ineligible. And clearly, the wording of this particular motion is affected. So if there was a consideration for a friendly amendment to basically say all the votes would be considered ineligible, and all we're doing is making sure that the community understands what the initial vote counts were, I would certainly consider that.
I would offer that amendment.
He amended the motion, basically.
So there's a friendly amendment to the motion that you change the wording to make all votes ineligible based on the motion that was just passed.
And so do you accept that friendly amendment?
Yes, I do.
And so is there a second to the motion as amended? And so I will take a roll call vote on the amended motion.
You have to have discussion. Point of order.
Okay.
You have to have discussion on the friendly amendment.
Okay.
You need to open the floor.
Any discussion? I thought it was discussed. So any discussion? Okay. So roll call vote. Tom?
Yes.
Doug?
Yes.
Frank?
Yes.
Yes.
Larry? Larry, your vote on the amended motion?
No.
Okay. And I don't really have to vote, because my vote would be tie-breaking, but I would vote yes on that. And so the motion now reads that you,
Is that right here? So change the wording, since on the
Yes.
friendly amendment, the wording would now say, move to conduct an official count of the 2021 election ballots to include all 4 of the candidates that were on the ballot and to designate all the votes as ineligible.
okay, is there any discussion on that?
What does that mean to do? We count the ballots and they're all
The ones you have now.
Right.
'Cause we're
Right,
gonna have a new
because we'll be
election.
conducting a new election.
Yeah, so what it would just essentially have is the vote counts for each candidate, but none of them would, they would all, just for informational purposes only. And so,
Okay, so I have a comment for discussion.
I have a question.
Okay,
I have a
Larry,
comment here.
go ahead.
You know, if we go along with this friendly amendment, and if at some point the judge says that Farr was eligible, we've already decided that all these votes are not eligible. And I'm not sure that's the correct thing to do. Jeremy, can you weigh in on that?
you just hold it. I'm just playing it out in my head for a second. Sorry. Right. And so, right. I mean, there is no mechanism, excuse right, for this anywhere. And so, if we were doing the vote count, we would deem him ineligible if there was going to be. The point of that is that if this were passed, we're just doing. It would be no different than if we did the vote. If we counted the votes the day of the election, but somebody raised a point of order at that election, and a candidate was deemed ineligible, we would have those vote counts. We would have the vote counts preserved. We deem them ineligible, but if the court says that Mr. Farr was, I guess there's just too many ways to think about it. Sorry.
I didn't hear the end of your answer.
Sorry, I'm trying to. I'm trying to be.
If the amended motion says that all of these are going to be ineligible, that's not appropriate. I don't believe.
Right, but there's no other way that I can. If we count the votes, I mean, I guess the other way to do it is we will count the votes.
I don't think the board has the ability to invalidate.
You are by.
Eligible.
Yes, we do.
eligible.
I mean,
candidates.
I think by doing the
Yes,
I think by doing the election, Larry, you are invalidating all of the existing votes
Sure.
by
By
redoing
passing
the
that
election.
resolution.
I'm
And
not sure I agree with that.
I mean, so what you're saying is that they're being preserved. They're being preserved, and then the new vote would be overturned. I mean, so this is sort of the issue with all of these, the way it could play out. We'll have to see how it plays out. I don't have a definitive answer for that. We're deeming them ineligible for the purposes of seating these candidates for the board based on where we currently stand. If the court comes back, if the court comes back,
that's exactly why I don't think we should be counting these votes unless directed by the court. We're starting to take steps here that there's no question that no matter what we do, there are a lot of bad answers. But and there's no doubt by doing a new election, the judge could come back and say Farr is eligible, and then we have to do what we have to do at that point. But to have a motion amended saying that we will count the votes, but they will all be ineligible, and if the judge does come back at a later date and says the votes from that election are valid, we've we've got a problem. So I don't agree that, again, by counting these votes, and particularly now trying to approve this motion based on what it has been amended to, I think is just very problematic. And I don't think that I think if I heard Steve Habecker say it's not, it's not appropriate, or, we had three eligible
that's not what he
candidates
said.
that have votes.
He didn't say that.
We've been ordered to maintain those votes, but we haven't been ordered to count them. And I don't think we should, and I don't think we should be invalidating the other three.
Doug?
Yeah, point of order. As advised by council, those votes are invalid now anyway. We're going to hold a new election. So by definition, those votes are already invalidated.
I think that's an off-the-cuff opinion, Doug. I don't know that that is actually
So,
true.
so you're basically saying our council is giving us off-the-cuff decisions? Is
Well,
that it?
I admittedly, I think if I'm just trying to play it out is what I think Larry, and I don't mean to speak for you, Larry, is what he's arguing is if we deem them all ineligible, we have another election and we seat the new board based on that election. And then the judge deems Mr. Farr eligible, and we've deemed these other ballots ineligible. Where does that leave us? But I guess is that we've already deemed Mr. Farr's ballots ineligible. And I guess, Larry, your point would be is if the court deems Mr. Farr's votes eligible, but doesn't deem the rest of the people's votes eligible, then we have a problem. Am I articulating that correctly?
Yeah, I think so. And if that is the case, then does that put us back in a position where we now have to have a third election? Because we've invalidated all the votes.
Colette, two points. I think we've already voted.
No,
And
we haven't.
We voted on the amendment.
We voted
We
on
voted
the
on the amendment.
What the
Okay.
amendment will
But-
say.
But I think that we talked about this a lot in court, but under the best business rule, I don't think, and speculation, I don't think a judge is going to say you can't do that if it's not violative of HOA law. Jeremy, your
No,
thoughts?
I think we could. I think you could count the votes. I don't have anything that says that you can't count the votes. That is a possibility if the board wishes to do that. There are, risk factors more than have been articulated here by doing that. There are also potentially some benefits. But yes, I think I can't say that you can't count the votes for the purposes of informational purposes only. But you basically have decided that you have the election that conducted this summer by the virtue of the motion that you just passed has effectively been invalidated, and you are moving forward with a redo of that election. Okay, and so those election results are all invalid with whatever they are based on the fact that we're redoing the election. Okay, I guess, and so that's I think the implication of that previous decision. So to answer your question, yes, we can count the votes. The benefit of that, I'll leave to you all to debate, but that is something that you.
Doug?
So I think with that explanation, you've got a situation where by the nature of the motion we passed, technically invalidates all of the votes that are currently being held. Okay, did I hear that correctly?
Yes, and
Okay.
preserved.
All right, so they can't be reviewed again or brought into any kinds of further discussion. The question would be, if the court finds candidate Farr eligible, and we are in the midst of this new election, what happens to those votes? All right, because by judgment, and correct me if I'm wrong, by judgment from the court, Mr. Farr's ballots will become eligible. Okay, we would have to have another meeting to say, based on judgment from the court, we are now going to turn around and validate all of the ballots from the previous election. Would that be the
I-
appropriate way to handle it?
So this is just speculation at this point because I don't want to get too far down this hypothetical path because there is no question by redoing the election and if we seat a new board, regardless of if you set a new board based on the current ballots or seat a new board with this, and Mr. Farr prevails, how the court will handle that is unknown. What the order will look like is just, I can only speculate at this point in time. In my brain, I've come up with 4 or 5 different possibilities, but I don't know how the court will handle that. And I think that of course, is one, when we were talking, you were all discussing that was one of the implications of moving forward with either, call it option 1 or option 2, option 3 being hold where we are, that no matter what we do in those options, there is going to, if Mr. Farr does prevail and the rest of the prevail, that undoing that wrapper is going to be complicated, and it may result, and this is just pure speculation, may result in a whole new election, may result in counting those original votes, may be reinstituting those original votes. The court can overturn your decision, reinstitute those original votes. I don't want to go down too far. Those are what we could.
At the end of the day, what I'm hearing is the membership of Ocean Pines wants to know the vote count. Plain and simple for information. Steve, thank you for informational purposes only. And I think we owe it to the membership to do that.
So I have a couple of comments here. You know, we're dealing in a lot of speculation, what I call the what ifs. You know, every decision we're considering is based on a lot of what ifs. And some of the what ifs sound like, okay, that wouldn't be so bad. Other what ifs sound like they would be terrible, but it's all speculative. I think what has happened in amending this motion is that we've created some more what ifs that muddy the water even further. And I'm thinking gee, I'd like to go back and take my yes back and make it a no. Because in hearing Jeremy speak and hearing the rest of you speak, I think we've really muddied the waters terribly by creating a situation that geometrically expands the number of what ifs that are there. And I guess what I'm left with is, you know, if this is for informational purposes only, you know, realizing that one of the big what ifs is that maybe these are all just invalid and it's just for informational purposes, to what end will we gain that information? I think I've heard almost everybody in this room who's spoken say that they would like this to come to an end. And I think what that means is healing the community, which is what Ms. Rogers has talked about. And I think we all agree that the community needs to be healed. And I think whatever actions we take need to move us closer in that direction. And I think counting votes for informational purposes only, one of the big what ifs with that could result in further fracturing the community. And so that is an opinion. Absolutely, you're right about that, Doug. And there have been a lot of opinions thrown around here. I think we are all speculating. And so what it comes back to is we all have to kind of search our souls and decide what we think is the right thing to do. Doug?
No, I would agree with you. Everything, we are dealing with speculation. But when somebody tells me, Doug, I would really like to understand and know what the vote count was, there's no speculation involved in that statement.
Okay, roll call vote. Tom already voted in favor. Doug?
What are we voting on here?
Okay, the motion is to conduct an official count of the 2021 election ballots to include all 4 of the candidates that were on the ballot and to designate all the votes as ineligible.
No, I'm sorry, is invalid, not ineligible.
Invalid, sorry, as invalid. Okay, so Thomas voted in favor. Doug?
Yes.
Frank, did you vote?
No.
So you're abstaining? Rogers?
Yes.
Brown? No. Perone?
No.
Did he say no, Frank?
Is Frank over
Oh,
here?
okay.
Yes, he did
I
say
didn't
no.
see it.
Sorry. And my vote is no.
Did
So
Frank,
the
Dale, did
motion
you abstain?
fails.
Did you abstain?
Yeah.
Yes, he did.
Did you abstain from this vote?
Yeah.
Yes.
But not, okay.
So the motion fails.
Quieter. So the motion fails. So the motion fails, but what I just want to remind the board is that under the order, as Doug indicated, all ballots have to be preserved, so they remain in place, secured by the election committee as where they stand, and so they will be continued to be secured.
Okay, and so the other conclusion from these three votes is that the election committee is being directed to proceed with whatever
Correct.
whatever plans you have in place or need to make to conduct a redo of the election with the three deemed eligible candidates. Do you have any questions about that, Mr. Hoppecker?
Well, I want to make absolutely sure we're clear. So our direction is to issue new ballots and receive them for 3 candidates, for which we already have their bios and all their information. We're prepared to do that mentally. We believe it will take 7 to 10 working days to produce the materials and fold, spindle, and mutilate and everything, and get them out. Historically, and in our bylaws, implicitly, it contains a nominal 30 days from the time the ballots are sent till they're received. We would request that that be moved to 6 weeks based on our experience with the U.S. Postal Service. Hence, we're talking 2 months, 8 weeks from today. I have a requirement for the board. We need a statement, letter, something in the document, in the package, that tells the members what this is and why it's here. We need to make sure, it's maybe hard for you to believe, but there are members who are unaware of all this turmoil, and we need to make sure that they understand. Now the ballot, the physical ballot, the mailing envelopes will be physically different. They'll be a different color. They'll be arranged differently. We're going to work on that. We have a meeting tomorrow at 1 o'clock in the afternoon in the boardroom. We have to electronically hook up to one of our members, and we're going to wrangle that stuff out. But it's going to be physically, mechanically different. So there's no chance of mixing up the 2 packages of materials. But in that package, we need something from you, the board, that says, what is this?
And
Now,
what is your deadline for us? To
the
get that
deadline,
to you?
as of next Tuesday, you will be the pacing item. Next Tuesday, you will be the pacing item. We have all the bios, we have all the mailing lists, the property owners and things like that. We have everything that we need but that statement. So starting Tuesday, from a production stand, print and fold and stuff and all that, you will start to become the pacing item.
So your charge to the board is to provide that statement by Tuesday and
Whatever-
close of business.
Yep. Whatever it is you'd like to provide.
Got it.
Jeremy, excuse me, Colette.
Yes.
Jeremy, because of the litigation that we're involved in, I think I would prefer that you go ahead and draft this statement as quickly as possible for our election committee.
Got it?
Okay.
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 I'm
Thank
going to
you.
apply for a bonus this month.
Meet me at the bar, I'll buy you a beer.
You get a raise, 0 for 0, so it's good.
Right,
Okay.
seeing that
no.
there's no other,
We
seeing
have,
that there's, hold
Larry,
on.
what were you saying?
Yeah, I said, seeing that there's no other business, Cammie, do you have an announcement to make?
Yes, I do. This will be my last board meeting. This has been very difficult for my family. It's actually, it's been horrendous, to get accosted in the pool by people who cannot let me enjoy an afternoon of being with my friends. My husband, that dear, dear man back there, went to the doctor and his blood pressure was high. And the doctor said to him, "You have stressors in your life?" And he said, "Yeah, I sure do." To which the doctor responded, "Oh, you're married to that Mrs. Rogers." And he said, "Yes." Mr. Trandick sent me an email, and I found it very amusing. He told me that I looked so stressed under the long examination that I went through that someone should made a videotape of it so I could see how badly I did. It's been this kind of activity that makes me sad to live here. I'm not saying we're going to move. I've enjoyed many of you. Jim Trummel, I will still serve on your committee if you'll have me. Steve Habiger, I'll serve with you anytime. But these are the kinds of things, threats to our lives, threats to our dogs, threats to, this has really, really been terrible. And I would ask the community to examine how you treat the board moving forward. We're volunteers. We make mistakes. Mr. Farr has suffered from this whole set of circumstances, and for that I'm very, very sorry. But I don't feel that the board members need need to be condemned. I really, really don't. We're trying to do the best job we can, but my family and I cannot take any more of this, so I resign.
Yeah,
So
can I
I
be-
formally,
We do appreciate your service on the board. We know it's been a tough time, and I know you and I have talked about it, and I do appreciate everything you've done for Ocean Pines.
Thank you, Larry.
Since we have everyone together, I'd like to see if we can arrange for a special meeting for next week to discuss a replacement for Camilla.
So do you have a date that you'd like to suggest?
Well, I'm sitting here. Why don't you guys? What does everybody have available? I think if we go, how about Wednesday afternoon sometime?
Not going to work for me. I could do afternoon of Tuesday, Thursday, or Friday. I could do Monday of Thursday or Friday.
How
Messed up.
about Thursday afternoon again?
I'm tied up next week with some family business on the other side of the bridge, so
Unavailable the whole week.
probably not till maybe Friday.
So Friday morning,
Mm,
afternoon.
No, maybe Friday afternoon.
Friday.
Kind of point of order. What is the intent of this meeting?
Well, we need to name a replacement for Cammie, Doug.
I understand. Are we naming a replacement, or are we going to discuss potential replacements?
No, I assume we would do what we did last time, go into closed session, have discussions, and then come out and vote on it.
Well, last time we didn't do that. Last time the person put on the seat for Steve Tuttle was already there and put on without us knowing. So that wasn't a discussion at all.
Absolutely, there was a closed session and we discussed two different candidates.
I beg to differ. I would like to see us have a discussion about potential candidates so we have time to talk to those potential candidates and decide how we want to vote. That was not a luxury afforded us last time, and I refuse to move forward unless we handle it in that manner.
Well, that's fine then. When do you want to get together for a meeting to have those discussions?
I'd like to check my calendar to see what days I'm available next week. And again, this will be a preliminary meeting to discuss potential candidates and opportunity to discuss with those potential candidates what they may bring to the board should we consider appointing them.
I don't recall that happening previously when we had two vacancies the year that Director Diller went off the board and Director Maroney went off the board. My recollection is that we had names kind of circulated by email and
Right.
then
That's
we
fine.
went in
Right,
and
that's,
voted.
that's fine, as long as there's preliminary information and we get an opportunity to discuss with the potential candidates.
Yeah, let's do that.
All right.
Just
Okay.
let's
So
circulate. names.
circulating by
Why don't
email.
we do this? Why don't we circulate names and then check your schedules and hopefully we can get together sometime next Friday and make a decision. But in the interim, today is Thursday. That gives us 7 days to go ahead.
Yeah, so Friday's not gonna work. We're not gonna have everybody. So why don't we,
Can I,
sounds like next week isn't
yeah,
gonna work.
help me understand the urgency of this. All right. So I mean, you know,
Well, the
Okay.
urgency is we need to get us another board member and we're having an officer resign also.
And we're having, as you pointed out, moving toward the budget season pretty quickly.
Well, we have 30 days to replace, and I think if we take next week to vet it, to
Okay.
decide which candidates each of us would like, and then vet them for the week, then we have a meeting on Monday of the following week. Because it
So
doesn't
the
seem like we
11th.
can get a day anytime next week to do this. Way to go, Cammy. Thanks a lot.
Is the 11th a holiday for you?
You can be secretary, Tom.
So the 11th, we'll have a special meeting.
I don't have my calendar in front of me, but
Okay.
float the idea
So let's-
Okay.
and we'll commiserate.
Okay,
Really.
alrighty.
So let's try to look for the afternoon of the 11th. Is that okay?
Sure.
Tentatively.
Tentatively, yeah.
Tentatively, yes, tentatively.
Okay,
That's Columbus Day, just so you know.
so I
right.
think we've concluded
Go
our
ahead,
business for today. Is there a motion to adjourn?
Yeah.
Doug,
Motion
Second.
adjourned.
Second.
the vote for adjournment? All in favor?
Aye.
Okay.